Honorable F. Rand Wallace, Judge, presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Okay, we have on the docket a matter of Mr. Williams. It's noticed in the case of Poe versus State, case number 2023-1522. Is Mr. Williams in court?
Yes, Your Honor.
All right, if you would approach the podium, sir. Okay, Mr. Williams, we're here on a setting of this matter by the judges that are on this panel, and it's myself, Rand Wallace, and to my right and your left is Judge Joe Boatwright, and to my left and your right is Judge Paige Kildane. So in this case, I think I need to put on the record how we got here. So we've got a notice of appeal was filed in this case on April the 24th, 2023. It was appealing orders of the trial court, judgment and sentence. Specifically, the issue was framed to us as the trial court erred in denying a motion for new trial and denying a renewed motion for judgment of acquittal. We ordered that you correct the certificate of service. In that case, you filed a new certificate of service, a new notice of appeal with a certificate of service, and then proceeded to file a number of motions for extension of time to serve the initial brief. I have, by my count, 7 motions for extension of time. I believe that at some point you failed to edit your motions requesting extensions of time because the one that is currently pending or was last pending in the court file, in the introductory paragraph to the motion, it cited it as your 3rd extension of time. By my count, I believe there are 7 extensions of time that you requested that we grant you. And the last one was titled Final Motion for Extension of Time. And in your introductory paragraph, it said, this is your 3rd extension of time. And in that motion, you said that you would have the initial brief filed within 96 hours or up to and including February the 16th of 2024. And still, there was no initial brief that was ever filed in the court file. And ultimately the case was dismissed. That was March 15th of 2024. Then your client, Ms. Poe, filed a motion for extension of time pro se. We ordered you to appear March the 15th, 2024. Our order was ordering you to appear here today, and you acknowledged receipt of the order, and I note that you were here today appearing in front of us. So, sir, I believe that this court has been more than patient with your request for extension of time. 7 motions for extension of time, in granting, all but the last one. I would like to have some sort of an explanation. I know in your file you referenced at one point dealing with personal matters, and all of us here are humans as well, and we understand that there are times when there are dire circumstances that need to be taken care of that go far beyond, we're not asking you to share with us deep personal issues or personal facts specific to your family, but at the same time, we did give you the ability to, extend the time to hopefully file something representing your client, and still there's nothing in the file and the case has now been dismissed. I also note that there was reference to, I believe, some sort of a death in the family, and then there was reference to being displaced from housing and to some extent. So, but, I still think that given the accommodation that we gave to you and allowed you to operate under should have resulted at least in something being filed in the court file, and nothing was ever filed. So what is it that you can share with us today? Because right now we're considering taking further action, which would include sanctions, which could potentially include reporting to the Florida Bar. Can you provide us with some sort of explanation?
Yes, Your Honors. And while I'm not here to dispute the number, certainly if the court has counted at 7, so be it. It was slightly higher than mine, but certainly the number to me would be irrelevant. It would be the underlying issues that led to those extensions. By my own timeline, it was the notice of appeal was filed on the date was correct on that, I believe back in February, on the 21st, but it was not until August 16th there was some confusion with the Public Defender's Office as to who was going to represent Mr. Poe. And so a notice of appearance was formally filed on the 16th to clarify and clear up any of those, 16th of August, excuse me, to clarify and confirm any of those issues. And at that time, that was when I believe the first extension was requested by my count, which would have put the date of the initial brief at September 15th or 16th of 2023. It was in early September where those family matters first arose. During that period of time, my teenage son, who's now with me, was not previously living with me. During that time, he was involved in a situation, and I appreciate the court's willingness to give privacy. I didn't know how much detail was going to be required. I even have a video of which I could share with the honors of one of the specific events that occurred during that period. In that period, my son essentially my son was the victim of a crime, and a violent crime at that. And after that time period, there were several other things going on. My son then was missing, which was put in the prior declaration, for a period of about 10 days, and ultimately came to live with me on or around October 8th, 2023. Based upon those matters, that's when the October 16th I filed the second motion for extension of time. When my son came to live with me, which was, a blessing as it removed him from the environment that he was in, it was one of those life-altering events. I am and had been a solo practitioner. I was someone who, not an exaggeration, worked probably 12 to 13 hours a day prior to my son coming to live with me. When he did, at that point, he was enrolled in school, enrolled in a program in which effectively I became principal, teacher, coach, and all the other things with that. And so my time was extremely condensed from what I was previously accustomed to working. And so rather than working 12, 13 plus hour days, we're talking about my time was significantly condensed to handle duties as a parent. Again, I don't say this as trying to think. I'm not saying these are parental obligations that I view as not as a chore. So I don't want that to that. But these were just the facts of the circumstances of what I was previously not undergoing and then was undergoing. So during that time, or not during that time, my son is still with me, he's actually in school now, but that's when that second motion extends in time. Based upon the event that happened with him and all that, we were able to get him into counseling. However, myself personally had not received any counseling or therapy for the events, and on top of that, for the events that I actually personally had to witness. As I said, there's a video of part of that, which I have if the court desires to see it. I'm the one who had to find that video. It wasn't the police. It was not a detective. It was me. I'm the one who investigated or did my due diligence and located that evidence for that video. And then the court is right. Again, in early December, I ended up in a situation with my son in which I was displaced and effectively didn't have housing from early December till about January 25th, 2024. As the court can imagine, that was also a trying time, trying to run a firm, trying to handle the altered lifestyle with my son, and still make his life as normal as possible under those specific circumstances. All the while, I'm still working full-time, or I guess it probably wasn't full-time, but I'm still working significant hours and trying to manage not only this appeal, but my entire caseload as a solo practitioner. It was certainly my intent, my goal, and my duty to have in belief that when I would give these 30-day estimates, as I believe most of the extensions had been 30 days up to a point, that was going to be significant time to get what I needed to get done. These were underestimates. I underestimated the time that I needed based upon these life events and based upon the additional juggling that I was doing. It was on February 9th where I believe, I thought the last one I filed was on February 20th, my last extension, in which it was sought for 96 hours, but I know I got a denial on February 21st, 2024, regarding that, I believe, February 20th request for extension. At that time, I did request 96 hours because the appellate brief, the initial brief, was effectively done. I believe that 96 hours, which is what, 4 days, over the period that I requested, at that point was actually going to be significant enough for me to complete the initial brief. And while it may seem like the brief is limited to the 2 issues, the brief is actually voluminous. The brief has, and I still want Mr. Poe to have an opportunity, so I don't want to go into the fact, or what I would consider the facts of the brief. But I will say that despite those 2 issues, there are several sub-prong issues under this brief that have made the elements of this brief, again, extremely voluminous and extremely more complicated than merely a denial of simply a motion, or simply the motion for new trial and the motion for judgment of acquittal. There's approximately...
You're talking about a brief that has yet to make it to the court file.
Yes, Your Honor.
And that's after numerous motions for extension of time.
That is correct.
I still haven't heard any reason why the brief has not made it to the file, other than it's voluminous. But I think you've had ample time to prepare that brief, to file the brief, at least in part, correct?
Yes, as far as, and I'm not sure what the court refers to by in part.
What is the excuse for not filing the brief?
Well, that's what, I mean, there was a point, and it was around, I believe, between February 21st and 26th, where the actual file got corrupted, and so I've had to effectively redo the entire brief. I've confirmed and consulted with the state, whether it be on my behalf or on Mr. Poe's behalf and pro per, and as far as the state regarding a motion for reinstatement, they've indicated that would be unopposed. But as far as submitting a brief, I mean, that was in part, I wasn't sure if it would be appropriate for oral request, but if not, then there would be a written request with an attached brief that could be filed certainly this week, in which the court would see the voluminous nature of the issues.
Mr. Williams, I appreciate you sharing everything that's been going on. It sounds like it's been a difficult time. Our concern is not only you and your representations and well-being and all those things that you've made to the court, but your client as well, because you are here on behalf of a client. Not today, you're here on behalf of yourself, but this whole thing matriculated through the system because of your representation. And my concern is with the representation. You, in either the first or second motion for extension of time, you represented that this brief was almost done. I think you used, but it was a term, it wasn't file ready. That was a year ago. Yep. Then all of these things matriculated, and then on February 9th of this year, in response to our order to show cause, you asked for us to dispense with the order so that you could file the brief. We gave you an opportunity to do that. In response, you filed more motions for extension of time, and then have still, as we sit here today, failed to file the brief. And now you want us to allow you to file it now. There is a point where if you have something going on that prohibits you from representing a client, do you not have a duty as a lawyer to withdraw from that case? At what point are we going to end this? Because your client has now filed things in this court saying, I want to represent myself, I didn't know what was going on. So that is a problem for this court. And for you to come in here and essentially ask for another extension of time in the face of over a year that this has now been going on, what would make us feel comfortable doing that in response to the reason that we're here today? And I guess that's where I'm struggling, and I don't think that that's really the purpose of today. The purpose is not for you to come in here and ask for more time to file the same brief that you have requested more time for a year. The purpose is to understand why you have been unable to fulfill that duty up to this point.
And Your Honors, when it comes to this specific brief, I believe that there's no one in the while this may be my first criminal appellate brief, I truly believe there's no one in a better position to file this brief than me as his trial counsel. Based upon what occurred in that trial, and again, I don't want to use inflammatory language for this proceeding, but given what occurred and having lived it as his trial counsel, I truly believe in Mr. Poe's interest that despite the things, that the outside factors, there's absolutely no one in a better who can articulate to this court what occurred and why Mr. Poe should be entitled to the relief that is requested and sought via the appeal. That is something I absolutely stand by, and the record transcripts and facts, I believe that in my heart of hearts as far as that's concerned.
That still doesn't answer the question. That doesn't answer the question why there hasn't been a brief filed and why you continued to move for extensions of time. I believe one of the reasons that you just placed here on the record, which to this date wasn't part of the court file, something about a corrupt file.
Yes.
That was not in anywhere in this file before the file that I reviewed. So you still haven't answered the question why you haven't filed anything yet. We don't have an explanation for your behavior.
Well, no, yeah,
For you to say that you're the only person that can represent the client in this case has been dismissed. This case is closed. So I'll give you one more chance. Provide an explanation as to why you haven't filed something in the court file.
Again, Your Honor, yes, well, as far as the file being corrupted, yes. So as I indicated with that, and I've had to draft and did have to draft the entire brief effectively from a shell scratch, which was, or not, well, not from scratch, but from a shell being what I call almost like an outline, as that was what remained effectively from the corrupt file. So effectively, you're looking at that being commenced back in February, is when that period occurred. But as far as, it was certainly my intent to come into court today, I mean, with that, and I certainly, again, when I say with that, I mean with the actual brief. I know exactly where it is. I mean, it's 85 pages. I know exactly what it lacks. I know exactly what what it needs to be as far as formatting. Realistically, I wasn't driving. I mean, if the court's concern is that it would not be there or that it would not be provided, I could alleviate that concern by even stating that I want to use the right word, by effectively staying and putting my, I guess, proverbial neck on the line to say that given where it's at, and given what I know about it, that if that period, that I could have it within that period, and that the merits of it would indicate the voluminous nature. The 85-page, although I was hoping to compress that slightly, as I believe 50 is still the limit in criminal. I know that's the limit in civil. But in any event, even if the court was to allow the additional pages, given what is in the brief, or even if that was to be filed as just an initial brief that was sent for back for amendment, certainly, I mean, as far as that could be filed now, but there would be I mean, I am a stickler, and I would say, for my work product, and so I would prefer to have made these adjustments, but certainly could send what is there now to this court. Again, it had been since February that it was, and it was late February, or mid or late February when that file was corrupted, and it's been redrafted from scratch. It is 85 pages long, and I believe that with the, should a motion to reinstate be granted, that the court will see the nature of the matters which warrant its review.
Mr. Williams, so I gather from what you're saying now that you're not prepared even now to file the brief, correct? You don't have it with you and you're not prepared to file it.
I would prefer, I could file, it would not be the product I would wish to file, however, I could file.
But you're not prepared to file it, is that correct?
That would be accurate, Your Honor.
Okay, all right. And Mr. Williams, can you just confirm, I guess I have for your current address, it's the Williams Law Group at 9600 South Dixie Highway, Suite 1311.
Yes.
Miami, Florida 33156, is that correct?
Yes, Your Honor.
And your phone number is 305-916-1122, is that
Yes.
right? And your email address is Andrew, capital A, at thewilliamslg.com?
Yes, Your Honor.
Okay. All right. Any other questions from the panel members? Okay. All right. Thank you, Mr. Williams, and we will stand in recess, and then we will just do a panel change and come back with the next case we have set for 1:30.
All right.